Good morning. Welcome to today's program titled Immigration and Recent Presidential Proclamations, What It Means for the Business Community. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. The session is being recorded. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to Masa Al-Askari. Masa, please go ahead.
Good morning, everyone. Thank you very much, Kelly. Appreciate everybody joining this Friday morning. We know everybody's ready to get their weekend started, but we also know that there's a lot of information and buzz out there in terms of what's happening in immigration today. So we're thankful that we have an opportunity to speak to everyone today. I'm going to start off letting everyone who is actually on the panel today to join the conversation, kind of giving a little bit of background about themselves. As for me, I'm a senior counsel at Seyfarth Shaw. I'm based in our downtown LA office. I've been practicing immigration law exclusively for the last 2 decades and focused on benefit side as well as compliance, have worked through audits and investigations with Immigration and Customs Enforcement and Department of Labor as well. So I'm excited to be here and join this conversation. I'm going to pass it on to Randy. We may have lost Randy. Gabe, how about you? How are you doing this morning?
I think Randy's on mute.
Okay.
And Gabe is on mute.
Angelo, how about you give us your background? We'll get there.
I'm Angelo Paparelli, and I've been practicing immigration law for upwards of 40 years. I practice with Masa in the Los Angeles downtown office. I'm a certified specialist in the field, and I'm an advocate for due process reforms in the immigration system.
Thank you. Randall, are you back with us?
Yeah, can you hear me, Masha?
Yes, thank you.
Yeah, thanks. Sorry for that. It's Randy Johnson. I chair the Government Relations Division here at Seyfarth. Prior to joining the firm, I was 20 years with the U.S. Chamber of Commerce as a senior vice president and 10 years on Capitol Hill as counsel to the House Labor and Education Committee. And prior to that, a stint with the Department of Labor handling largely regulatory issues and a few miscellaneous other jobs before that. Gabe?
Hi, guys. Can you hear me? Good morning, everybody. Gabe Moses. I'm a partner in the Atlanta office, formerly of the Boston office of Seyfarth. Just like Masa, I've been practicing for about 2 decades. Most of the work is in immigration benefits, particularly within the field of management consulting. Go ahead, Leon.
Good morning. My name is Leon Rodriguez. Unlike the rest of this group, I did not spend the majority of my career as an immigration lawyer. I was mostly a federal and state prosecutor until becoming the director of U.S. Citizenship and Immigration Services in 2014, and serving in that capacity until inauguration minute on September 20th of 2017. Here at Seyfarth, I am a partner in the Business Immigration Group, and my practice is primarily focused on litigation, investigations, and public policy and government relations.
Great. Thank you, everybody, and thank you, Leon. I do wish you were still on the other side, I will say, just a preference on my end in the previous administration, but we've all been excited to have you here on board on this side. So really, we wanted to take the hour today to spend some time talking through a lot of what we're hearing in the press and online. I know there's a lot of information, some misinformation, some confusion given the presidential proclamation. So our session today will walk through the two proclamations that have impacted immigrant visas and most recently non-immigrant visas. We'll talk through some of those exemptions that were identified in the latest proclamation in terms of H-1B, L-1s, Js being able to enter the country. We'll talk through as well about anticipated future regulation. We know that that's in the news, that's on top of mind for everyone. Are there going to be changes in country? And there is a difference between where we are now with the current proclamations and what we might see in the future. So where we are now is very specific to people who are outside of the country. Where we are in the future may relate to what's happening in country with filings. So we'll really try to distinguish between those two and answer a lot of those questions that are out there. And we'll touch on with Randy and Leon's help, and Angela will touch on what litigation will look like, both in terms of the proclamations and the regulations that might be forthcoming. And then most importantly, we'll talk through how do we impact the narrative that's out there right now? How can we be part of that narrative as a business community, as a community of people with a global workforce? So we're excited to be doing that. Next slide, please. So our presidential proclamations, you know, we start out with a proclamation that was issued initially on April 22nd, 2020. You can go on the next slide, please. And I think I understand there might be some audio problems. I know our tech team is working on it, so hopefully that'll be resolved quickly. But just really quickly, we wanted to talk through the first proclamation. It was a bit of a surprise for everyone. It came as a tweet, and then immediately afterwards, the proclamation was issued back in April. And it was very specific. You know, there was concerns, and there's still concerns to this day when we get phone calls about, does this impact me here in this country when I'm here processing my green card? Does this impact my associate and my team members? And the answer is it's very limited. It only impacts individuals outside of the U.S. Who were seeking their green cards through consular processing, meaning they were going to go to the embassy, attend their interview, get their immigrant visa stamp, and then be able to enter the country. So it's actually a very limited population. And logistically and practically, it didn't really have too much of an impact because our embassies were already closed down. They weren't doing immigrant visa interviews or non-immigrant visa interviews. So really, it was more of a symbolic gesture than anything else. So that was the first one, and it was pretty limited. Then we come to this week where we received the second proclamation, and it impacts a bigger population because now we're talking about non-immigrant visa holders. Those are who are coming into the country temporarily in either H-1B, L-1, J-1 status, or H-2B status. So if you're not in the country, if you don't have a visa stamp in your passport, this proclamation basically applies to you. And the reasoning provided was tied to COVID-19 a little bit, the market conditions and unemployment rates given COVID-19, but really, it really, again, is limited in nature because the visa processing at the consulates has been shut down anyway. Gabe, kind of give us your thoughts and background on what you think this proclamation means for the businesses in practical terms and the reasoning used for it.
Right. Well, the reasoning that the administration is advancing is one where, because of COVID and how and its effect on the U.S. labor market, we are looking at a situation of very high unemployment rates, and the government is looking for some way to get U.S. workers back to work. The theory that the administration is pushing forward is that U.S. workers will be, once they're able to re-enter the market, they'll be competing with foreign workers. And you know, the arguments against that, of course, are, well, you know, foreign nationals occupy a lot of technology positions. 2/3 of H-1Bs hold tech jobs, and the actual unemployment rate within the technology space has actually dropped considerably to even under 3%. So currently, as Massa described, we are in a situation where we are we're actually trying to figure out exactly what the proclamation says. It is written as in a very deceptively basic way. It is, you have to meet 3 conditions and then you are subject to it. In practice, though, we are still trying to gather evidence specifically about it. But basically, as Masa said, outside the United States, no non-immigrant visa and no other entry document to be able to enter the United States. These are the 4 visa classifications that are targeted: H-1B, H-2B, J-1, and L-1. And there are a number of exceptions that we'll be going into in a little bit. Angela, why don't you tell us a little bit about kind of the wording itself and why it's kind of leading to a little bit of, ambiguity.
Angela, you're on mute.
Angela, you're on mute.
Sorry about that. The wording itself says the suspension and limitation on entry of this proclamation shall apply only to any, I like to use the word non-citizen, who is outside the United States on the effective date of the proclamation, does not have a non-immigrant visa that is valid on the effective date of the proclamation, and does not have an official travel document other than a visa, such as a transportation letter, advance parole, or appropriate boarding foil. By listing 3 and having at the end of the second requirement an and in the preface saying this applies only to these 3, it seems clear that someone who is in the United States on the effective date of the proclamation would not be subject to it. However, the Department of State on Twitter in an exchange has officially listed a Q&A that has said that if you're in the U.S. and you leave after the effective date and don't have a visa, you cannot come back in until the proclamation period expires on December 31. So that has caused
Angela,
Twitter. Go ahead.
Sorry, you mentioned it's very clear, and that's an interesting term to use because it's actually anything but clear, as we're discovering, right? So this is the Department of State FAQ you mentioned is one of those that's trying to make this statement even clearer, although we're still confused. Gabe, what are some of the recent kind of
Well, I was
developments?
saying it's clear from a linguistic standpoint.
Right. Right. So it depends on how you're looking at it. Gabe, in trying to really get to the heart of this statement and whether or not it's clear, what are some of the things that we have been hearing? Because, there's a lot of questions. I'm Canadian. What does it mean to me? I was outside of the country when this was issued. What does it mean to me? Talk about some of the developments that have been going on just in the last 48 hours.
Right. So when it first came out, we were thinking, all right, so you're in the U.S., so you're safe, right? No matter what status you're in the United States. So as Angelo said, and is the word that we're looking for. All 3 conditions must be met. And so you're in the USNH status, your visa expires, you can apply for one. Of course, when U.S. embassies and consulates reopen, and of course, taking into consideration the fact that there are travel restrictions because of COVID. Or you're outside the U.S. with a valid H visa, it might be expiring. Of course, you're going to be able to renew it because on the day on June 24th, you then have a valid visa. So you are exempt from this ban. Well, it turns out, and we're in a very new world when we're getting guidance through tweet storms. It is if you look at what the Department of State is saying, first of all, they put out a number of Q&As that they've put together themselves, and then a lot of foreign nationals were asking some very good questions. And Department of State, they were responding via tweet. And some of the tweets we were seeing seemed to be inconsistent with the actual literal language. So for example, as Angelo said, which I completely agree, if you are in the United States and you have an H-1B, you're in H-1B status and it's expiring, can you go abroad and just renew it? According to the proclamation language, seems like you can. Department of State said no, they're not issuing these. Or if you're outside the United States, you have a valid H-1B visa stamp right now, but it's expiring in 2 months. Can you just renew it while it's still valid? The answer was no. I mean, of course, presuming that the consulates are going to reopen. The answer was no. We are in a state right now where we're in a information gathering period. We are waiting to hear more information. We'd like to see something more official from the Department of State. We would love DHS to chime in. We're waiting for more information. I will tell you, Customs and Border Protection has answered a few questions. We don't have official guidance yet, but CBP has stated that they expect Canadians to be exempt from the entire proclamation. So it's a little bit of, making this up as you go. But Canadians appear to be exempt from this proclamation. And in addition to that, automatic visa revalidation seems to be something that will continue, which will be, helpful, of course. We're still waiting for additional guidance on some of the, treaty-based visa classifications, the H-1B1 free trade for Singapore and Chile. We believe that, this should not affect these kinds of treaty-based visa classifications, but again, we are not sure. So the way that we are approaching this now from a very practical perspective is as conservative. We'd like individuals, we'd like employers and their foreign nationals to certainly reach out to their counsel. We'd like to take a conservative approach here. If you're in the United States, you're maintaining status, we'll extend status. If you're outside the United States and you would like to come in, I think that's a good conversation. We are literally getting information every day now. And so what's happening on the ground is a little bit, as I said, different than the proclamation itself. I think we'll get a lot more information, especially with some of the advocacy organizations, particularly AILA, looking for more info there. So in addition to that, we want to talk about exceptions to the rule because that's just another category. So I'll just turn it back to you guys.
Thanks, Gabe. So, and just remember, kind of Gabe talked through some of that clarity that we're looking for and confusion between what the proclamation says. When Leon and Randy start talking about the litigation and the policy, that will be key. But Leon and Angela, can you take a few minutes to talk through what we did see in terms of notes in the proclamation about exceptions that will be allowed for people to still obtain their H-1Bs, provided visa appointments can actually be scheduled at the consulates between now and December 30th.
Right. So as did the April 22nd immigrant visa proclamation, there is a series of exceptions that are laid out in the order based on the administration's assessment of particular needs and policy priorities. Those exceptions include providing labor services essential to the U.S. Temporary labor, incidentally, to the U.S. Food supply chain, sort of a broad national interest exception, and then a more specific set of exceptions for activities that are critical to defense, law enforcement, diplomacy, or national security. People traveling to the U.S. For reasons involved with provision of medical care and or medical research related to COVID-19. And then there's an economic recovery exception that Angela's going to talk about in a second. But before we get to that, I think it's along the lines of some of the discussion we've already heard this morning to talk about two things. Is, what is going to be the process, what has been the process for invoking these exceptions, and secondly is how are these exceptions going to be interpreted? So right now the chief process for invoking these exceptions has been at the consular level. And so to Massa's point of, if you can even get an appointment, you won't be able to actually invoke the exception until you actually get yourself a consular appointment, which is in itself an exercise of trying to invoke exceptions to what has generally been a practice of not scheduling consular interviews, which in most of the world is still continuing as we speak. But also the order speaks about exercises to be undertaken by Department of Labor, Department of Homeland Security, and the Department of State to further interpret these exceptions. and to list out, potentially list out more specific activities that fall within these exceptions. Now, these exceptions exist in their plain language right now, and what that means as a practical matter is that what they mean right now will, for the most part, be decided by the consular officer who's making a decision as to an individual's visa application. There could come over time to be more specific rules about these. Whether those will be more expansive or more restrictive than the way these read right now, that remains to be seen. But one strategic question I think folks are going to be left with is, do you invoke the exception now when they're sort of general and vague, or do you wait until they get more specific? And I think that's a question that is sort of merits some debate. And Angela, I'd love to hear your reaction to that.
Well,
but I think yeah, go ahead.
Just a little clarification. There is a process to request an emergency appointment on the DS 160 non-immigrant visa application online. One can request an emergency if you make an appointment first. So if you can make one long into the future and then request it, you can get an opportunity to interact with the consular officer. In addition, though, the consular officers have generally followed the guidance of the visa office in Washington at the State Department. And, for example, the various entry bans from countries afflicted with COVID-19, the EU, the UK, elsewhere, have had a national interest exemption. And while it did not expressly state economic national interest, there has been virtually a categorical refusal to consider any form of economic national interest. And there's been humanitarian grants of exemptions and emergency appointments, but nothing of the sort on the economics front. And when I say that, I don't mean harm to only an individual visa applicant or an individual petitioning employer. I include harm to an industry, a region, to the U.S. national interest in export sales that would promote our balance of payments and trade. None of those have been considered at all at this point, according to senior folks in the Department of State. Now, when we look at the current proclamation, it is even more difficult to achieve because it doesn't merely talk about economic national interest. It says to facilitate the immediate and continued economic recovery of the U.S. Well, you almost have to accept the premise that the economic unemployment rate is caused by non-immigrant workers, which is quite a stretch to embrace the terminology here. One would hope that in these deliberations that are interdepartmental, that they will come up with categorical recognitions. There was a great deal of pressure before the proclamation came out to exclude the L1A, executive and manager intra-company transferees, from the scope, but that effort failed, and it's not clear whether they would now be considered on a categorical basis to be eligible for that exemption. It's a tough set of words to satisfy immediate and continued economic recovery. How do you make that argument? But the irony is that there was nothing done to touch the treaty visa categories, particularly the E1 and the E2 and NAFTA, and yet the L1 is the only category that is comparable to the E2 investment category, where an American company doesn't qualify for an E2, only can get an L1, and their executives and managers from abroad can't even come in to keep the plant running. So you can imagine the effect on the outcome of people making decisions for the long term in the C-suite, in which they decide America is just not welcoming enough or not reliable enough, and that would have devastating consequences.
So, I guess a question for you. This last exception, where they're talking about activities necessary to facilitate immediate and continued economic recovery. How would you, what arguments would you make? How, absent sort of specific enumerated occupations or industries that come under that section, how would you marshal the argument for that exception?
Well, let's take an industry like oil and gas. That affects the Gulf region, Texas, Louisiana, Oklahoma. There are numerous companies that serve to try and promote U.S. export of energy, and it's the effort might be to demonstrate that a key manager would be coming in to facilitate operations that would promote economic growth, promote export sales. Sadly, however, that has not been sufficient under the bare bones national interest exemption of the previous entry ban. So unless there's a relaxation in this halls of the executive branch at the highest levels, it's going to be extremely difficult to make the argument. You can make the arguments, but it seems to fall on deaf ears.
We definitely have a combination of making the right argument, but also just logistically and practically, how does this work, right? Because we always go back to what does this mean for the business and the timeline for it. Not only do we not have visa appointments being scheduled, but now on top of that, we have to request exceptions to be made.
One technique is to go on Google and type in key officers of foreign service posts, and you will find every foreign service post has a fax number. And it's ironic in this age that we would send something by fax, but that's one technique people could use.
I like that. So we're going to move on to talk a little bit about what we think future regulations will look like. And before we do that, I just want to point out a couple of clarifying things. We have restrictions that are related to these proclamations, and then we have COVID-related travel restrictions as well, and those are very different. We have a lot of questions coming, especially from Canadian nationals coming into the States. Those restrictions related to COVID-19 that have to do with crossing over the land borders. And I know people get confused and they think there's a complete travel ban against any Canadian coming into the U.S., and there really isn't. So really do reach out to your legal teams to talk through the nuances of that, because not everything applies to everybody. And TNs in particular are not part of this proclamation, and they're not restricted from entering. So, Leon, can you talk through some of what we think we'll be seeing in terms of future regulations? And if we can go to the next slide, please.
And Leon, before you jump into that, we've received a question in the chat. So speaking of future regulations, what do you expect to see an impact on individuals who already have an approved I-140? And additionally, do you expect to see any impact with USCIS in terms of eliminating premium processing?
Yeah, that's two very, very great questions. And let me kind of dwell on the second one, because I think that is going to, about premium processing. Because one thing that may become a really significant factor in how this unfolds is the current financial woes being experienced by USCIS. So as probably most of you know, USCIS is currently experiencing a deficit of $1.2 billion. It has asked Congress for a bailout. And it has already advised its staff that if that bailout does not come by early August, they will need to furlough roughly 60% of their workforce. And so in terms of the ability to sort of, both generate regulations, but also develop exceptions, these exceptions that we were talking about just a minute ago, one thing that's going to play a role is whether there's actually going to be anybody working at USCIS a month from now. I think is going to be a significant issue. In terms of regulation, I think historical context here is very important in terms of understanding where these regulations may have come from. So the kinds of things that we're hearing about, the kinds of things that people in the administration have been talking about, are things that have been on the agenda for discussion basically since this administration took office. So if anybody's been watching the regulatory agenda over the last 3 years, I'm the sort of geek that does, then you will see these topics: employer-employee definitions, specialty occupation analysis. You will see that these topics in the H-1B context have been on the regulatory agenda for a very, very long time now. There is some sense, though, that the administration may use the cover of the COVID pandemic to in some way accelerate these policy changes that they've been talking about for a while. We've seen in their adjudication practices already evidence of both a sort of recalibration on both of these issues. So we've seen a lot of denials based on a conclusion that a petitioning employer could not demonstrate that the individual employee or intended employee was in a specialty occupation analysis. We've seen lots of requests for evidence, lots of site visit activity around the question of the employer-employee definition. And so what it's been doing in many respects in practice, it looks like USCIS may try to accelerate that using the COVID pandemic as cover. Could there be a merit-based process? That is entirely possible. There has been some indication that the administration could pursue some regulatory process that would favor the upper salary tiers for various visas. Whether they have the authority to do that absent legislative change is something that is debatable. And so if any of these things happen, one thing you can count on, and I think we're going to talk about that in just a few minutes, is lawsuits all over the place.
Right.
You know.
And we really have seen a lot of this in the context of requests for evidence. We've been successful in those challenges and getting approvals through either the responses, motions to reopen, or litigation on case-by-case basis. And part of the reason we're successful is because the regulations and the law itself don't support the decisions that are being made by the service center when they redefine specialty occupation or redefine employer-employee relationship. So I think that's probably what we're going to see in regulation. I don't think it's going to be anything brand new, aside maybe from any sort of merit-based, salary-based kind of analysis that they may try to add in there. But it's something that we've been seeing for the last couple of years, so it's not really going to be too much of a difference there. But we do know that at least they'll go through the regulatory process this time, which will be helpful. Next slide, please. The other component that we saw in the proclamation itself is the request by the administration for the agencies to look at and consider promulgating regulations in relation to the second and third preference categories. And this relates to the immigrant visa sponsorships, the green card sponsorships in country, right? And typically, most of these will involve what's referred to as a PERM process, where we do have to conduct a test of the U.S. labor market through the DOL filing. So there's already a process established to safeguard U.S. workers in this context. So the question is, will that change a little bit? Will they add additional components to it? The test of the labor market includes posting the jobs. It includes the ability of the Department of Labor to conduct supervised recruitment. It includes the ability of the Department of Labor to conduct audits. So there's already safeguards there. And it's a matter of seeing where they think they're going to go with it in terms of adding to it or changing it. So we don't really know a whole lot of what's going to be there. I would venture to say that whatever is presented will probably lead to litigation, which I'm going to go on to the next topic, because this really does fall into what does it mean for us when these regulations come out?
Masa, before we do that,
Sure.
let's just mention a couple of other things quickly. The proclamation does cite Section 214G3 of the Immigration Act, and that section, they're saying, might show preference for protections of U.S. workers, avoidance of harm to U.S. workers. And there's nothing in that section whatsoever that talks about that. That is just a first-come, first-serve allocation under the H-1B visa lottery. And with regard to the DOL and the DOJ's authority to conduct investigations, the DOL is somewhat hampered under the text of the statute at the present time. Can't self-generate investigations, can't use the contents of the I-129 non-immigrant visa petition as a basis for an investigation. And so there are constraints now, and so an effort to change things by regulation, I think, would be met with a great deal of challenge.
Exactly, and that leads us perfectly into our next topic to talk about what we see in terms of litigation, not just on potential regulations, but more importantly, right now what we have at hand is the existing proclamations. If we can go to the next slide, and Leon and Randy, I'm going to turn this over to you to kind of talk through a little bit about what we see in litigation, both for the proclamations and what could come about if we do see regulations for the H-1Bs and the EB, the employment-based categories. Leon, you're on mute.
As everybody can imagine, a lot of organizations, either business organizations or immigration organizations, have been very active in watching the development of these proclamations, and additionally, the regulations that may follow from those proclamations. So already there, for example, the American Immigration Lawyers Association sued the administration seeking a temporary restraining order and preliminary injunction for the first of the immigration proclamations, the April 22nd proclamation. That litigation is still ongoing, but I think we can expect that there's going to be similar litigation coming from multiple quarters challenging this most recent proclamation, particularly given where we started the discussion today, which was that the impact of the first proclamation was relatively narrow. The impact of this one's actually going to be quite broad. But it also calls a few things fundamentally into question. One is whether the president, in fact, had the authority to issue this proclamation in the first place, whether the statutory authority they cited actually gives him the right to do what he did. But also, we're talking about an area that both from a statutory perspective and a legislative perspective is very well developed, and is very well developed on the specific issue that was used to justify these proclamations, which was the notion that elevated U.S. unemployment somehow necessitated these proclamations, notwithstanding the fact that in our employment-based immigration scheme, there are very specific and considered legislative choices about where we impose labor market tests as a criteria for visa availability. So at least those two arguments, not to mention a bunch of other process arguments, are going to be the subject of litigation from various different potential organizational plaintiffs. I think one of the interesting things that we're going to be watching is whether individual plaintiffs, in other words, individual companies or even individual people, will also find it in their interest to pursue litigation, either themselves or in some sort of coalition among them, so as to provide cover. And so that's something, certainly that we're going to be discussing potentially with our client base or with others who might be interested in pursuing that sort of litigation. But all of this raises the very real possibility, as we've seen before, as for example we saw with the early travel bans, that these proclamations may in whole or in part be halted by a federal court and then be tied up for many, many months in litigation long past their actual effective date. So that's something that I think that could bring about some change, and something I think really merits watching in terms of whether these orders are eliminated, their effectiveness is eliminated altogether, or where they are modified in a way that then will cause us all to modify the way we approach responding to them. You know,
it's Randy. Let me just jump in on. I know as far as the regulation. I mean, there's the proclamation challenges and then the regulatory challenges, and there's some good, credible talk that the administration, perhaps not totally surprisingly, will shortcut the APA and go use the so-called technique of an interim final rule, which basically.
Just really quickly, Randy, that just for those who may not be aware, so the APA is the
Administrative Procedure Act.
Right, and, which requires a notice and comment period. So the question is, will they bypass that and go directly to an interim final regulation and not give stakeholders the opportunity to review and comment on the regulations?
Right, and in fact, under the APA, and I've had my hands in using interim final rules at my time at the Department of Labor, but it's a shortcut that does allow the agency to go immediately to a final rule without notice and comment rulemaking, but then say, however, we're still accepting comments, and so later on we'll issue a real final rule. Interim final rules per se aren't recognized under the APA, but they are used, but the agency must justify skipping the notice and comment, even though it's asking for the notice and comment later, under what's called good cause under the Administrative Procedure Act. And that's impracticable, unnecessary, or contrary to the public interest. But the bottom line is that there's a ton of case law on this. Unfortunately, the courts have invariably construed this good cause provision, even in the context of an interim final rule, which is asking for comment, as shortchanging the APA and interpreting that phrase very narrowly, such that the agency really has to demonstrate, if it's not a statutory mandate, a true type of emergency. And so if the agency goes forward with this, yeah, it'll save them some time because they don't have to deal with comments. But it's short-sighted and would be, I think, Leon, a very fat target for us in litigation. It's backed up by a lot of good case law in favor of litigants and the public.
Right, and that's actually, Leon, what you and I have talked about a couple of times, right, is like, do we prefer interim federal regulations so that it will be almost automatic litigation and injunctions that will drag this out longer rather than the comment? Either way, it might get us into the end of the year with no real effective change.
Yeah, no, that's absolutely correct, given the timelines we're talking about here. That and the election itself, all of these kind of play in a factor in what the right strategy is in terms of what the administration's trying to achieve, but also then what's the right strategy for the employing community to use to respond when these things occur. I think,
sorry, go ahead.
No, I personally think that an interim final rule will be seen as an overreach by a court, and so. In that respect, it may actually give a very quick way to actually stop the litigation, such a regulation in its track.
Right. Yeah, I totally agree. And it'd be foolish to pursue that, but there have been some past examples of this administration where they have. So we'll see what happens. But
well, it might be better than the proclamation or the DOS FAQs that went out by tweet. So on that note, let's move on. And I think this really is a great segue into our last topic is policy advocacy and how do we change and support the narrative that will support kind of economic recovery, growth, and the global workforce that we really do depend on across the board. Next slide, please, Randy. I'm going to turn this over to you. This is your
Marcia, and thanks. And let me just say that based on my 10 years on Capitol Hill and 20 years with the Chamber, in this world, if you don't push back and make your case, you're going to get rolled, and that's as true here as anywhere. And so the executive order does actually say that it leaves room for modifications in the future based on a report by the Secretary of State and the Secretary of Labor. So there is an anticipation of modifications, and of course the president can modify it anytime he wants anyways. So to just sit back and say, well, we've just got to comply with this and let's see what happens, it seems to me is a foolish strategy. We really need to take the time now to push back on this executive order and make our case, so at least it's not worse, and hopefully will get better as time goes past. And this isn't rocket science, but we really need, for those of you on the phone, hopefully to get involved in an effort to approach some of our friends on Capitol Hill or at the Department of Labor. Perhaps not so much at DHS, frankly, but at Department of Labor and Capitol Hill, and say this isn't a great idea. It's bad for the economy. Immigrants don't take jobs from Americans, etc. And we've helped past companies with talking points when they've talked to the press on this issue. We're willing to do it again. We can coordinate a type of campaign on this, to try and just pull people together in an effort to say, look, Mr. President, this really isn't such a great idea, and here's why. And we can help on talking points along those lines. We can develop a bit of a strategy. Again, it's not heavy lifting. We're not talking about political contributions or anything like that. It's just pushing back and standing up and making the case, which we can very well make, and we have helped other companies do so when talking to the media, et cetera, and we're willing to do that again. So I'd like to add this part of it. Yeah, go ahead, Masha.
Sorry, Randy. So I know, when this proclamation was being discussed and, the news was going out about it, the chamber was really big as well, just reaching out and asking for organizations to provide stories, narratives to share with the agencies, because the agencies were going out to the chamber and asking, give us the anecdotes, give us the information that we can use to really push this in the direction that will not harm the economy more than it will help. So in any respect where organizations are comfortable in going out there and sharing their stories, I think is helpful.
Right. So if you're willing to kind of help in this effort, I know we're going to send out a follow-up email, but please get back to us, and hopefully we can develop a pool of companies that are willing to put their shoulder to the wheel here a little bit and push back on this bad policy.
Right. And some of it includes just phone calls, emails, letters, right, to your local congresspeople, and it really can start at that level, because the voices need to be heard. I'm going to take a minute, go back to the litigation, because, Leon, I meant to ask you your thoughts and comments on the impact of the recent Supreme Court decision on DACA, in terms of what the administration will continue to do or not do, or do differently as they promulgate either regulations or additional proclamations or executive orders.
Well, it's interesting, because I think you already saw the impact of the DACA decision in the way the administration wrote this most recent proclamation. So, if you look back at the April 22 proclamation, it was very light on justification for the proclamation. But then, you had the Supreme Court in the DACA case say two things. One, you need to give, when you're going to make a change of this magnitude, you need to give a real justification. You need to consider policy alternatives to accomplish whatever those policy justifications indicate, and you need to take into account reliance interests in that. So all of that, I think, is going to matter to the litigation that's going to undoubtedly follow this most recent proclamation and any regulations, because, in fact, there were a couple of 100,000 H-1B applications that were filed at the end of March. Those were employers, those were people that were relying on having those visas available at some point this year. And now that reliance interest is being squashed. So I do think the DACA litigation, the Supreme Court's DACA decision is going to play a pretty significant role in the kinds of arguments that you're going to hear be made against the proclamation.
It really definitely is interesting, and I saw the difference too, and we talked about this, and we thought it was kind of a nod to that decision and them trying to have a little more reasoning behind their proclamation. But what I've noticed as well is under both of those proclamations, that the underlying themes is these individuals are coming into the country and taking jobs, especially those coming in as green card holders. They'll have open employment. Every one of these involves positions that were already associated with this individual. So they're not open positions out there in the market, and they're not the positions that are being lost in the layoffs and the furloughs and et cetera. So it's interesting when you kind of really think about it, even this current proclamation. So if you were an H-1B holder in country, you left on vacation, you're stuck abroad now because of the COVID-19 travel restrictions, and you had gone to get your new visa stamp, there was no open position in the U.S., right? You had that position. So now we're telling you can't come back in for the rest of the year. Or what if it was your family member who went abroad and they were applying for their visa stamps? And that's the other part of it, this disruption in the family unit, right? So if you had your spouse and child on vacation, they got stuck and they don't have a visa stamp, now they can't come back until next year. So just a lot of those practical logistics of how is this impacting day-to-day work, family, and travel overall. So definitely a lot to think about.
And Masa, just one thing to add, one of the things that we've seen a lot are individuals who have traveled abroad as dependents looking, H-4, and they had appointments, and COVID shut down those consulates. And the Department of State doesn't look to be honoring, individuals that had appointments prior to the proclamation, or even individuals that attended their appointments and were put into administrative processing, and will get their visas issued after June 24th. So there's also that to consider. And there's a lot of, it seems already like there's a lot of organization with various organizations and other groups and litigation about this one specific family separation issue, because that's becoming a very big one.
Exactly, and it doesn't seem to serve the purpose of limiting new workers into the U.S., right? Because their spouse and child are not part of that workforce. I do want to share really quickly the CLE code for this session. It's SS Seyfarth Shaw 0812. Again, that's SS Seyfarth Shaw 0812. And as we're nearing the end of the hour, we have about 9 minutes left, and we're going to open that up for Q&A. And I know we had some written questions, so Tyranny is going to help us kind of go through a few of those.
Sure, thanks, Masa. So Gabe, the first question's for you. Understanding there is still some uncertainty here, will you discuss the impact on H-1B extensions for those presently in the United States? And in addition to that, do you expect to see any changes to the H-4 EAD program?
So just very basically, the ability to file stateside H-1B extensions with the Service Center, that is unchanged based on this proclamation. So those employers that are looking to file extensions for their H-1B employees are encouraged not only to apply and submit those petitions, but try to do it on the early side. Obviously, we're looking at, as Leon mentioned, a potential furlough, and so, and which may or may not affect the premium processing program, and you kind of go both ways. On one sense, there are fewer individuals. On the other sense, the agency needs more money. So we don't know exactly where that's going to go, but it has not. This does not affect stateside extensions. So that is something you should work with your account teams and make sure that you're able to file those. As far as the H-4 EAD, this proclamation does not affect the H-4 EADs. Those can still be applied for. We've heard plenty of rumors. I mean, this has been on the docket for this administration to rescind the H-4 EAD for years. They've run into economic arguments. They've had plenty of issues there. It's an interesting. It rises and then it dies down again, and it may come up again. And through all the regulatory changes that the government's looking to promulgate, but right now it's not top of the line, top of the agenda. So I think we're okay for right now.
Yeah, and if you do have, thanks, Dave and Tierney. If you do have questions, if you can type them into the chat box, we'll get to as many as we can. Go ahead, Tierney. Thanks.
Thanks. Matt, so the next question is for you. So we've received a question about the impact on J1s. So can you just elaborate on which categories have been impacted by the most recent executive order?
You know what? I'm actually going to turn this back to Gabe because I know he's been delving into it really a lot lately. So.
Sure. So it's individuals that are involved in a J1 program for interns, trainees, au pairs, and summer work. Our understanding is that it does not affect individuals who are in academic degree granting programs and are issued academic training. Now, I will say we need to be careful. Again, back to this whole kind of let's play this conservative. I wouldn't want any employee getting into a conversation with a CBP officer about the nuance here. So, I would try to encourage employees that, even if you're on a J program and you're working on academic training, to obviously remain in the U.S. And if you do need to travel, speak to your employer and speak to your account team here at Seyfarth, because we are, as we were doing earlier with the COVID-related restrictions, there's a lot of liaising that we're doing with the border. We're calling CBP constantly to make sure we can get people in at a certain time in a certain classification. So make sure you talk with us and we can steer you certainly as more information comes in.
That's a really good point, Gabe, about CBP. It really is very fluid, and not just in terms of what they're allowing or not allowing, but also which port of entry, right? So that really does require a little bit more strategy than just showing up at the border. So that was a really a good point to bring up.
Thanks, Matt and Gabe. Leon, you had discussed some of the financial challenges that USCIS is currently experiencing. Do you expect the USCIS furlough to impact service centers in the same way that local ASC offices have been impacted since the pandemic first began?
Yes, or worse. The USCIS closures have largely affected field offices and ASCs. The field offices, of course, reopened at the beginning of this month on a limited basis, focusing particularly on naturalizations, which means that a lot of these issues are sort of not part of the picture at this point. But a furlough of the magnitude that has been forecast by USCIS will have to affect service centers. That's the largest part of the overall USCIS operation. And so specifically with respect to these employment visas, which is our area of discussion here, the vast majority of that work is handled in the service centers, and I think there will be a pretty considerable impact. And the question I failed to answer is what will happen to premium processing. I do think there's a meaningful risk that premium processing will once again be suspended if there are mass furloughs, because there simply won't be the workforce on hand to meet the premium processing deadline. So that's something I think as people plan what they're going to be doing between now and the beginning of August, I think that's something very important to take into account. Use that premium processing now because there's no guarantee that it'll still be here as we move into the fall.
Thanks, Leon. And that was a great segue into our next question. So Angela, we've been receiving a lot of questions about premium processing. So do you mind commenting on the strategy here and whether you think premium processing can change the adjudication process in terms of the increased likelihood of a denial?
Can you hear me? I'm not sure. I've had a computer problem. Can you hear me?
Yeah, we can hear you.
Okay. many times that calculation has had to be made in advance because premium processing has a refund obligation, and especially with the financial woes of the agency right now, the last thing they want to do is refund the premium processing filing fee if there is not a response within the 15-day mandate. And so what often happens, at least one perceives from the outside, is that a burdensome request for evidence is issued that covers everything plus the kitchen sink, and it might not have been issued if regular processing had been asked instead, because an officer would not have been under that pressure to worry about being dinged for a refund of funds that they don't have to give back. So that's always a calculation. It's going to be dependent upon the strength of the case.
Thanks, Angelo. Massa, the next question is for you. Could you just discuss how the most recent proclamation has impacted H-1B transfers, specifically new hires moving to a new H-1B employer?
Sure. Before I do that, really quickly, CLE code again is SS Seyfarth Shaw 0812. As Gabe mentioned earlier, this proclamation does not impact any in-country filings, extensions of status, amendments, change of employers. None of that is impacted by this proclamation. The proclamations, both of them, really relate to individuals who are outside of the U.S. seeking entry into the country. So it's very limited in that context. And also remember, this second proclamation does not apply to TNs. It does not apply to O1s. It does not apply to the E-visa categories. So all of those categories are still available for individuals outside of the U.S. seeking to enter the U.S. Of course, that's with a caveat that if you're not a Canadian citizen, you're going to need to get a visa stamp, so you're going to need an appointment at the consulate to get your visa stamp. And with that, we're a minute past the hour. I don't want to take up anyone's time any more than we had promised, so I appreciate everybody joining. Thank you to everyone on the panel. We hope that this was a useful and helpful session for everybody. We know that there's a lot of information out there and a lot online. We will share the slide deck as well as our Q&A on the proclamation that we posted on our web and had as an alert as resources. If you do have specific questions, reach out to your legal team at Seyfarth. Hope everybody enjoys the rest of the day and your weekend. Thanks, everyone.
Thanks, Ron.
This concludes today's webinar. Thank you for attending.